At the end of the closing statements, the judge will stand up and bow to the lawyers. The lawyers will also stand up, bow back to the judge, and the judge will leave the courtroom. And then the judge will often come back in and give the lawyers feedback, which is one of the most important parts of the mock trial. Gives the judge an opportunity to say to the lawyers what worked and what didn't work, and give them some tips for future experiences that they might have. And the judge will occasionally in a mock trial either give a decision or give the lawyers some sense of the way that they were leaning in terms of making a decision. But the important thing to remember is that in a mock trial, it's really not a win or a lose kind of situation. What you're really doing is getting the experience, and often the judge's decision will be just a result of the facts that you're given and not something that you did right or wrong. So it's important to just take away from the experience the tips that the judge gives you.
Thank you, counsel, for your assistance. I'm going to take a break of a few moments to consider the evidence as well as your closing arguments, and I will return in a few moments' time and render a verdict.
All rise, please. Court is recessed. Order in the court, all rise. Court is now reconvened. Please be seated.
Okay, I'd like to thank all of you for your patience, and I would like to commend counsel for the very able jobs that you did. At this point, I would ordinarily give a detailed review and assessment of all the evidence. However, given the nature of this exercise, I am going to be very brief. Mr. Donovan Tissey has been charged with robbery and assault causing bodily harm. In particular, it is alleged that on the evening of March 10th, 2010, Mr. Tissey and another individual brutally attacked Mr. Enver Williams and stole his running shoes. In order for Mr. Tissey to be found guilty of these offenses, the Crown must establish the essential elements of each of these two offenses beyond a reasonable doubt. I have no doubt that Mr. Williams was indeed assaulted and robbed the evening of March 10th. The sole issue in this case is whether it was Mr. Tissey who was one of the two individuals who was responsible. I do not question Mr. Williams' credibility. However, there are inherent frailties to eyewitness identification, notwithstanding that the identification is honestly made. There is an unfortunate record in this country of cases in which individuals have been wrongfully convicted on the basis of eyewitness testimony. The court therefore must be very cautious in relying on this testimony alone as a basis for a finding of guilt. I also found Mr. Wong to be a credible witness. I accept his testimony that he indeed did see Mr. Williams on the evening of March 10th at some point before 8 p.m. It is possible that Mr. Tissey would have both been in the alleyway the evening of March 10th, encountered Mr. Williams at that time, and then gone on to the recreation center, at which point he saw Mr. Wong. However, there was no evidence before me as to the time it would take to get from Mr. Tissey's home to the recreation center, except for Mr. Tissey's evidence. I appreciate that Mr. Williams had a horrible experience the evening of March 10th. It is understandable that he would want to see the perpetrator called to account. However, our criminal justice system requires that before someone can be found guilty of a criminal offense, their guilt must be established beyond a reasonable doubt. In the circumstances of this case, based on the evidence that I heard, I conclude that the Crown has not established its case beyond a reasonable doubt. Mr. Tissey, I would ask you to stand now. I therefore find you not guilty of the two offenses with which you have been charged. You are free to leave. Thank you.
All rise, please. Court is adjourned for the day.